Thank you. The notice for this meeting refers to Inns of Court on practice directions, and directions is in the plural. And while the emphasis is undoubtedly going to be on the practice direction on proceedings before the Commercial and Tax Division, we cannot lose sight of the practice direction to standardize practice and procedures in the High Court, which was gazetted as Gazette Notice 189 of 2022 and was published on the same day. There is some duplication between the two practice directions. For me, if any proceedings are pending in the Commercial Division, the Commercial Practice Direction will take precedence on such matters as pleadings, witness statements, case management, and hearings. There are, however, several areas in the General Practice Direction which we must be aware of. Item 9 is dealing with format, which is going to be important for us because it sets font sizes, margin sizes, and line spacing, which will greatly reduce the amount of information we can get on a page. So we need to be careful in negotiating how many pages we're going to write in our submissions. There's also useful stuff in item 24 on the restriction on when cases will be listed for mention and how they get listed. And in item 38, there's a change from the old court rate of interest of 12% in the 1982 practice direction to 14%. A matter for discussion is that only applies to the High Court, and it leaves the Magistrates' Court still running at the lower rate of 12%. This practice direction is a combination of the earlier practice direction that we had in 2014 on case management, with new matters added into the case management portion to deal with the concept of virtual and physical hearings. And as Mr. Justice Babea said, the second part is on actually conducting virtual hearings and how we deal with witnesses and statements of evidence. And that was submitted to public participation before the Chief Justice asked us to combine the two practice directions into one. The preamble to the practice direction makes clear that it applies to all proceedings before the Commercial and Tax Division. That's mentions, directions, case management, submissions, hearing of applications, and the main hearing of the case generally. The introduction, which unfortunately has lost its numbering in the Gazette notice, should be listed as item 1. It sets out that for the Commercial Division, the practice direction replaces Order 11. So if we've got cases pending in the division, we shouldn't be referring to Order 11. We should be referring to the practice direction. It also records the satisfaction of the judges in the Commercial Division that conducting hearings on teams complies with the requirements of Order 18, Rules 3 and 4 of the Civil Procedure Rules regarding witnesses being present and the judge recording proceedings. Most importantly, it makes clear that the virtual proceedings and judgments and orders made virtually have the same effect as physical proceedings, judgments and orders. So we must get away from the idea that virtual proceedings are informal, we can turn up in our beach shirts and so on. It has the same formality and the same seriousness as proceedings in a physical court. And finally, on the introduction, I would draw your attention to paragraph B, which makes clear that the court will strive to complete all hearings within 90 days from the commencement of the hearing. So while, as Judge Mabea said, the desire is to finish a hearing on the day it starts, the intention of the judges is that we will not have lengthy adjournments. If something starts, it will be finished within 90 days. The case management portion of the practice direction starts at paragraph 2 in the practice direction. I think it's important for us to remember that the Civil Procedure Rules 2010 made two very fundamental changes to the way in which we used to conduct proceedings. The first was that we're now required to file our statements of evidence and bundles of documents with the pleadings, not work on this over the length of time between close of pleadings and the hearing date. In practice, under the old rules, that generally, I think, meant running around in the last 2 days before the hearing started, trying to find your witnesses and your documents. We're now required to do all of that up front. And the second aspect was the introduction of case management, or I should say the reintroduction of case management, to see that the parties are complying with the requirements of the rules and that everything is ready to move forward. The problem with the old Order 11, as it originally introduced in 2010, was that it was very bureaucratic, with far too many forms to be filled out and far too many appearances. And when Mr. Justice Musinga took charge of the division in 2012, he produced a practice direction to shorten a lot of the documentation and to try to make the procedure more consistent with the aspirations of a commercial court of giving speedy decisions efficiently and cost effectively to commercial people. That assisted greatly, but when Mr. Justice Kimondo took over the division, he had a meeting with the judges and he came to the bar bench to say that the judges felt that the practice direction had not gone far enough, that the judges wanted to take control over the way in which proceedings are prepared and the preparations to see that they are ready for the hearing. And he set up a subcommittee of the Bar Bench Committee, which was chaired by Mr. Justice Havelock. We had very clear directions as to what the judges wanted to see dealt with in that practice direction and to ensure that cases really were ready to move on for hearing when they were set down. And that led to the 2014 practice direction, which has to a very large extent been adopted in the new Order 11 brought in 2020, but not entirely. That 2014 practice direction is now subparagraphs A to P in the present practice direction that we're now looking at. The COVID pandemic has opened our eyes to the possibility of virtual proceedings, and I would think it made us accelerate our move to virtual proceedings by 5 or 10 years. And we must take advantage of what we've been forced into doing, which will save greatly on time. The transition between one case to the next case in court proceedings has been shortened. We're saving on travel time. We have the luxury of continuing to work at our desks while we wait for our case to be ready, and we can have all our papers ready instead of trying to balance them on the end of a table and find the right page and so on. So there are many advantages to this. There are some disadvantages which we will discuss during the course of this afternoon. Whether we look at a virtual hearing or a physical hearing, the intention is the same: to do justice while making the best use of judicial time. What exactly does case management in the commercial division require? Firstly, after the close of pleadings, any party may file the case management checklist. And I emphasize any of the parties can do that. You don't need to wait for the plaintiff. If you file the checklist, you must fill in the preliminary matters in items 1 to 4, which we will look at in a few moments. Then you serve that and you invite the other parties to fix a date at the registry for the case management conference. 7 days before the case management conference, all the parties should file a request, which is in the prescribed form in Schedule B, which sets out all the things that you want to have the court consider in the directions. At the case management conference, the judge will go through the directions, will take control of the areas where he thinks the parties are not concentrating, and eventually he will set the case down as ready for hearing and fix a hearing date. The practice direction does say that case management will normally be on a Friday. That was a subject of considerable discussion because I think that rule is broken more often than it is honored. And the feeling was that normally suggests flexibility so the judges will decide when they are most comfortable dealing with case management. So it won't necessarily be on a Friday. The idea is that the judge will hopefully have 10 or 15 minutes to look at the matter, and it won't just be rushed through as a short mention would normally be. It is, however, very important that if the case management should be effective, that the advocate who has the conduct of the case or someone who is working closely with him and is very familiar with the case should be attending case management. It's not something for sending the newly admitted advocate along. You need to be ready to answer questions and for the judge to be asking you whether something can be agreed upon, whether concessions can be made. So you need to be there with somebody who has control. It's very sad when you hear a judge asking, can we do this or that? And a very young lawyer is just saying that all I've got is instructions to say we have complied. It has to be more than that if case management is to be effective. The case management provision at paragraphs L and M provides for how bundles and statements of evidence are to be prepared. Every page in the bundle of documents should be numbered. We recommend at the foot of the page, leaving the top right-hand corner for any appeal to the Court of Appeal. It's desirable that your documents should be in chronological order because that facilitates both the judge and the other parties following the flow of the documentation. But there is flexibility if you in your discretion feel that it would assist for clarity and understanding to separate the securities or to separate reports or opinions or pleadings in another case into a separate section of the bundle, then you have that flexibility. But clearly mark the different sections and clearly number each page in chronological order in its section. It's also desired that we keep the documentation as small as possible. So if the plaintiff has already included a document you want to refer to, there is no need to put that into your bundle of documents. You can simply refer to page X in the plaintiff's bundle and deal with the matter there. It's only if there is some material change in your copy of the document or something important that you should duplicate the documents in your bundle. But there does seem a tendency by some advocates to feel that they have to put every document that they want to put in because it is my bundle. We should be looking at this as our bundle for the hearing of the case and sharing the documents across. The requirement on statements is that it should identify all documents referred to or relied on by reference to the page number in the bundle. And I emphasize relied on because there is a practice of just throwing in hundreds of documents, not referring to them in your statement of evidence. So neither the judge nor the opposing side know exactly what they're there for, but just in some forlorn hope that if something happens, you may find the answer in that bundle. Documents in the bundle should be identified in the statement of evidence and clearly show why they are there and what purpose they are serving your evidence. This will facilitate cross-examination and will avoid lengthy re-examination in reference to documents for the first time and objections that follow from that. The intention is that at the hearing, the witness will adopt his statement of evidence and produce the bundle of documents. And there should only be minimal highlighting before the witness is subjected to cross-examination. This does mean that it's important that we see that the statement represents what the witness himself wants to say and that everything that the witness wants to say is actually set out in that statement. We're aiming to eliminate surprise and avoid judgments while people try to take instructions for cross-examination. One of the aims of the case management is to reduce the size of the cause list. If you look at the judge's cause list each day, probably there's 20 matters which are applications or mentions. And the practice direction provides that, save in the case of an injunction filed simultaneously with the plaintiff, all applications that you wish to make, whether they're for particulars, for discovery, for interrogatories or amendments of your pleadings, should be made as part of the case management conference. When we look at the checklist, we will see that there's provisions for making your application in the case management request and getting that dealt with at the one hearing. This will enable the judge to make all the relevant interlocutory decisions at the one time and focus on seeing that everything is now in order and the case is ready for hearing. There will still be some mentions, but hopefully if we all follow this and endeavor to deal with everything at the case management, we will greatly shorten the cause list, and as Judge Mabea says, allow the judges to get on with the important work of hearing substantive cases and determining them. Important bits on applications is that on an injunction application, either during when it comes up for hearing or delivery of the ruling, the judge may proceed to convert it into case management and give immediate directions for the hearing. This would greatly shorten things if a judge could direct that the affidavits are treated as the pleadings and statements of evidence and get on straight away to a substantive hearing rather than the situation we have just now of arguing everything on the injunction application as a sort of rehearsal for the hearing, and exactly the same material is dealt with again at the substantive hearing. The affidavit in support of the application may refer to documents in the bundles. So there's no need to attach a great bundle of exhibits. If your bundle is there and the documents are there, you can refer in your affidavit to page X in the plaintiff's bundle, page Y in the defendant's bundle. And we save the bulk of documents that have to be filed and looked at. One thing the judges were adamant about when we were doing the 2014 practice direction is that any application to strike out should be made at or before the case management conference, and that they will not deal with applications to strike out subsequently. So if you feel you've got grounds to strike out, you need to get that done at or before the case management. Something that is new from the 2014 practice direction, but was carried forward from Mr. Justice Musinga's 2012 practice direction, is paragraph 2(n)(5), which deals with certificate of urgency. It sets out how you apply for urgency, and it also gives you the right to ask for an oral hearing before the judge if your certificate is refused. That's a practice that not many people had remembered from 2012. What is also new in the case management section is the portion from paragraph Q to paragraph U, which is dealing with the questions of the directions to be given for a virtual hearing. And one thing I would draw your attention to is that the judges did say that the default will be that hearings will be virtual rather than physical, so that we have to make out special grounds if we want a physical hearing. I would like to, if Honourable Tanui can let us look at the Schedule A. Is it possible to put Schedule A up on the screen? I think we're getting there.
Okay.
A bit further on. There we are, Schedule A. Thank you. Now, this is the case management checklist. And when we go through this, you will see the simplicity of the system and why it's not such a hardship. The first thing is that, and the first line, the nature of the claim. The judges had indicated to us in 2014 that they found it helpful to have a very brief idea of what the case is about, whether it's a mortgage suit or a bank loan recovery or an insurance claim. So it's just a 4 or 5 word description of the claim. Then you have to fill in the case number, then the names of the parties, the plaintiff and the defendant. And we were asked that we should insert in there the name and address of the advocate. This is to facilitate for the court being able to contact the parties if there is any need to do so. Then we get down to the body of the checklist. So the first thing we have to fill in is the details of the pleadings that have been filed, the plaint, the defense, and the reply. Then we get down to the details of the statements of witnesses and the bundles of documents, both for the plaintiff and the defendant. Now, if there are additional plaintiffs or defendants and you're using a soft copy of the form, you can put in extra boxes for first defendant, second defendant, and so on. These are the preliminary matters, paragraphs 1 to 4. And the tendency nowadays is that the deputy registrars will look to see whether these have been filled in. And if there is any gap, somebody hasn't filed their statements or their bundles of documents, it will be immediately visible from the first page of the checklist what is missing, so the deputy registrars can give directions on when those should be filed. And as you will see, they have power, firstly, to make an order for compliance, and then they have space for an unless order. In other words, making a default order that if you fail to comply, either you won't be allowed to produce evidence or your documents, you're not allowed to produce documents. So there is a provision for default. Now, one of the things that horrifies me when I'm listening to case management is, firstly, the question that is asked by registrars and judges is, have you complied? To which the answer is usually yes, or though often with some uncertainty, or maybe I want more time to file this or that. This is not a question of the end of the case management. You do not comply with case management simply by filling in the first page. We had a system of summons for directions mid-1970s and 1980s, which had a long 4-page menu of things that you could ask for. And that was so frustrated, it ended up being just asking for the last prayer hearing in Nairobi, 2 days, and it got repealed because the lawyers, and I'm afraid the judiciary assisted the lawyers, just did not treat it seriously, and it got abandoned. Compliance is far more than filling out numbers 1 to 4. So if we can move on then to the next bit. The first question that comes up at 5 is alternative dispute resolution. And I think it's now agreed that the best time to decide whether a matter should go to mediation is when the pleadings have been closed, the statements have been filed, and a judge is looking at it. So you can anticipate that on the case management, you will be asked, should this go for mediation? If not, why not? So you should be ready to deal with that. Then when we go to 6, we find a series of questions relating to pleadings. Do you want to amend your pleadings? Do you need to file additional witness statements, additional documents? Do you need particulars? Do you need interlocutory relief? Do you want to apply to strike out? And at 12 is other applications, because although discovery is no longer in the rules, there's still a provision for it in the Civil Procedure Act, so you may want to ask for other things. The idea is that you can attach your application to the request form, which we will look at in a second or two, and simply say that you want to amend your pleadings as shown in the document attached, or you want to file the additional witness statement attached. And that way you can deal with all of these applications at the same time. I should add that the request form is the absolute mirror of the checklist from question 5 onwards. So then we get to 13. Are there any objections to admissibility of any statements or documents or any part thereof? And when should such objection be determined? And this is important because people throw all sorts of hearsay statements into their statements of evidence. There are documents which are disputed and you want the production of the original. These are matters that we should be thinking about early on in the case. And the intention is that you should raise this on the case management conference to indicate, I have a problem, I object to that statement as hearsay, I object to this document as not being genuine, I require the production of the original. These matters should be brought out at this stage. And there's boxes for your objections, and the judge will fill in what the directions are on that. 14 is the important point, question of issues. It is the obligation of the judge to frame the issues, but the judges expect us to at least make an effort at doing this and to agree the issues. And I know one of the judges will insist that we agree the issues before he certifies the case is ready for hearing. Then at 15, there are some questions about how the case will be dealt with. Does it need to be consolidated with another case? Is there an agreement for a case stated for the opinion? Do we want to have a test case? So if we have about 10 cases on the same matter, you may want to either consolidate them or treat one of them as a test case. You can attach your application to the checklist and have that dealt with. Then come a series of questions directed at your witnesses and the evidence. Do you need witness summonses? Are there admissions of statements of evidence so there's something that's very minor? Are you prepared to agree that that statement can be admitted in evidence without calling the witness? The aim is to reduce costs and to reduce the time of the hearing. Do you need to put some evidence in on affidavit? Do you want discovery, production, or inspection of documents? Do you want interrogatories? Examination of witnesses on commission if they're outside the country, which isn't so important now because we can do a virtual hearing from outside. And do you need directions regarding examination of accounts? All of this designed to make us think about how we're going to present our evidence, what is really an issue, and can we shorten the amount of evidence that has to be called? Which then leads on to 23, which is expert reports and directions from the court as to which experts are we able to agree on expert evidence, directions for exchanging those expert statements, because what the experts say may have an impact on how we want to proceed with the case. 24 is whether we need directions regarding the production of a chronology where there's a lot of different transactions that have happened and it's important to see the time sequence. Do we need maps, plans, or diagrams? The hope being that such things can be agreed on and put in as agreed documents. Then we get to 25, which is dealing with the hearing. First of all is seeing that there's an index bundle of all pleading statements and documents filed by the parties. Are we doing it physically or virtually? And if so, are we putting together a physical bundle, or are we ensuring that the bundle is available virtually? This is important because we have to see that our witnesses all have access to the documents so that they can answer questions. How much time is required for the hearing? And this is always difficult because you never know how somebody's going to respond in cross-examination, but we should make genuine attempts to try and work out how long it will take. Then the important new question, should the hearing be physical or virtual? As I said, the default will normally be virtual. And then is the case ready for hearing? And the judge can certify it. Now, the expectation is that as the judge works his way through this list with you, he will be giving directions. He can either write them in his normal record or he can write them on the checklist, and it can come back for compliance at a mention. If we can look very briefly at the request form, we will see that it has an abbreviated version of the heading from the checklist, and then it starts with question 5 on alternative dispute resolution. The reason being that the first 4 questions are filled out on the checklist. So from here on, the questions and the numbers correspond to the checklist. So if in your request you say that you want, for example, item 6, I want to amend my pleadings, you can fill in as per the draft amended plaint attached here too. And really there's no need for evidence on or affidavits on such an application. Other party may consent, or the judge can deal with it by looking at it there. And the idea is that the judge can deal with these matters in a summary matter and move forward with dealing with all of this. The intention is that if we work through the checklist together with the opposing party and with the judge, that for the judge, there's the certainty that this case is ready for hearing, that there won't be unnecessary adjournments, and that there will not be unnecessary documentation and evidence called. So it's just to shorten the time of the hearing and to allow the judge to get on with the determination of the matter as quickly as possible. The advantage for us as advocates is that we are forced to think about our client's case at a very early stage, so as to know whether we have a good case or what gaps there are in our case and get evidence, and to ensure that we assist the speedy and efficient administration of justice, but also that we present our clients' cases in the best possible way. Thank you, and I believe we deal with questions at the end of the other two presentations. Thank you.